starting out with State of Ohio versus Richard Fortune. And are both sides ready to proceed?
Yes, sir.
Yes.
You each will have 15 minutes to present your argument, and the appellant may have up to 5 minutes for rebuttal. And so whatever, when you come up, just let me know if you want to have some time to save for rebuttal.
Would you like me at the podium? Or
Yeah, at the
closer?
podium, please. And we are, I was going to tell you too, we are videotaping, recording, so please stand behind the podium and keep your voice up. And don't say any victims' names, please. Just refer to them as a victim, or if it's a child, or
Certainly.
whatever, or initials if you can think of. Thank you.
Thank you, Your Honor. May it please the court, counsel. I will, for purposes of concision, rest on my brief and answer any questions the court may have, with the exception of a few general comments that I believe that, when taken in the aggregate, the issues presented for the court in this case and the indisputable facts preserved in the transcript about what occurred during this trial and in some senses outside of this trial.
Let me stop you right there, if you don't care. You didn't indicate to me if you want to say it anytime. I know you say you're not going to be taking much time, but.
I will save the 5 minutes for rebuttal, Your
That's
Honor.
it. Thank you.
That I believe that the aggregate issues presented for this court are such that even if the court were to agree with the state's arguments in any single issue, that the cumulative weight of the errors and wrongs done to appellant in this case are such that the court is left, in my opinion, with no option but to reverse this case for further proceedings. And I would yield the rest of my time on argument. I will not rehash the great deal of issues presented in the brief and the voluminous transcripts, especially since I think it would get, as the court has expressed its preference, a little difficult with the sheer volume of acronyms and initials that would be needed here. So I will rest on the brief and the transcripts and preserve some time for rebuttal. Thank you, Your Honor.
Just a second.
Yes.
The court may ask some questions.
Certainly.
And one of the questions I want to ask is in regard to the PSI. I'm not sure, and obviously we'll go through the record in great detail. I don't know if there's any information, if there's a record of the PSI that the court relied on. Because there was no PSI in this particular case.
Correct.
But there was an overload, a prior.
Yes, Your Honor.
Is that in our record?
I do not believe that it is a part of the record, Your Honor, no, because it was merely something that the trial court referenced its knowledge of, but I do not believe was included or made part of the record.
Is there any indication on the record when the trial court might have reviewed the PSI? I mean, is there any record that the court had that in its custody and reviewed it before trial began?
I don't believe the trial judge made any specific comments to that effect, Your Honor, not to my recollection. So I am not, I don't believe that he makes a specific, and at this point, prior to trial, I reviewed this or anything like that. Obviously, I think given the argument that we are making to the court, if he had admitted to such, I would have raised it in my brief. It's obvious that this is prior existing knowledge before the trial court.
Well, that's what I'm getting at. How do you know it's prior existing knowledge before he began the trial?
I believe that he has, because he is referencing a prior case from some years ago that he was involved with, I believe, a grand theft auto or
But
something.
even though he was involved with it, how does that demonstrate that he remembered about this juvenile record or anything prior to that?
I believe because the comments about the juvenile record are contained in, are themselves look backs from that time, and this was something he felt was so pertinent, he discussed it on the record as things he found pertinent in the sentencing. And essentially the argument is, if in a situation like this where the trial court is the trier of fact, if there had been a conventional voir dire with the jury panel and someone were to have said during questioning, or would have been obligated to answer under questioning, yes, I'm aware of these alleged prior existing statements by the juvenile, and that is, something I deem pertinent. These are pertinent comments or pertinent information to me, however attenuated, however hearsay within hearsay they may be. No certainly no defense counsel is going to let that person sit on the jury, and I would like to think that no impartial trial court would object to a motion to recuse that particular juror. So,
Well, what about though, when I was reading it, I was thinking, trial judges every day have defendants in front of them, that they had defendants before in front of them. Might be several times they've had the defendant on other cases. And it's the defendant's right to have a jury trial or to waive that right and proceed with the bench trial. And the defendant knows that the trial judge has already had him prior, so he understands and he's going to have some knowledge about him.
I believe that certainly, which is why our argument is not that because he presided over any prior cases specifically of appellant, that is the Constitution or the basis in and of itself. Our argument is not, well, he's had him before, and therefore there's a problem. Our argument is he's had him before, and specifically there are these comments that he himself, in a case where he didn't order a PSI or anything to that effect, says in the sentencing hearing, these decades-old alleged comments from a time where the defendant was in a juvenile facility, were so pertinent to me that in a case where essentially there isn't any discretion in sentencing, there really isn't anything for me to weigh or balance here because essentially my hands are tied by a statutory sentencing imposition. I nonetheless feel obligated to point out that this was important to me, these comments, from this case that I was prior on.
But nonetheless, the judge found him not guilty of certain offenses.
I believe this is where my initial remarks come into play. He did find him not guilty of certain offenses. However, in our opinion, first off, from a pure bare bones adversarial position standpoint, the court only needs one. You get life regardless. If you found him not guilty of all but one, but that one has life, then that, if in fact, per the trial court's comments about a defendant and his opinion of him, then one charge is enough. So merely acquitting on some does not resolve the issues. And moreover, in our opinion, as raised in our brief, I believe in the fourth argument, it is the appellant's contention that the facts of this case, the testimony that came out during trial, it is not logical to acquit on one but not the other, because essentially the stories and the allegations are so interlinked between these two accusers that to claim one is credible and one is not, and one has not met the burden of proof, but the other one somehow has.
Have you argued that have you argued this in your briefs?
In the manifest weight section, part of our argument in manifest weight is that it does not make logical sense when the accusations are this intertwined for the trial court to say half of this is credible and half of it isn't. It surely, by logic, must be all or nothing. Either you believed that this pattern of conduct occurred or it did not, because the accusers are interwoven in their narrative. So that does make sense, though, if you are proceeding under the theory, as the appellant is arguing here, that the trial court has and makes comments in sentencing about grooming, and this is repeat offense behavior, dating back to these allegations about alleged juvenile comments.
Does he make those comments in justifying a life sentence, saying a life sentence is appropriate given the history I know here? Because there's that presumption, of course, that the life is not biased during the trial.
I understand, Your Honor.
These comments came during the sentencing.
These comments came during sentencing. He is essentially, as my recollection, concedes that it's a life sentence, because it is.
It's a mandatory.
Correct. Which is why the fact that he goes on to say, this is, in other words, he could have just said, it's a life sentence, I found you guilty, this is the sentence. I haven't ordered a PSI in this case because there wouldn't be any point, because there is no discretion for me to exercise, and therefore no need for me to take in investigatory material with regards to determining the sentence. That in and of itself would legally have been probably sufficient, given that, as the court, as you have stated, Your Honor, that it is a mandatory sentence, and therefore, when the trial court in this case says, I didn't order a PSI, we accede that he is correct to do so, or at least that it is within his discretion to do so, and that the lack of a PSI in this case has not violated any rights since it's a mandatory sentence. Our argument is that he then goes on to say, notwithstanding all that, here's this prior information from well years and years and years ago that isn't even confirmed. These are alleged statements made by a juvenile in a juvenile facility that occurred in a PSI in an unrelated case from years ago that I thought were so pertinent, so important to my mind, that I have to put them out here.
Pertinent to his mind, or did he say pertinent to my decision in finding the thing?
He is.
It's a fine line.
Yes, Your Honor, I would agree, but I would respond that if in fact he has some pre-existing bias here, as we are arguing, of course he is not perhaps foolish enough to say, on the record, lay the groundwork for his own appellate argument. That the mere fact that he is not foolish enough to say the magic words that would automatically give this court grounds to reverse the case does not mean that the court is barred from considering the totality of the circumstances here. In other words...
Counsel, you're at 4 minutes.
Okay.
It's up to you whether you want to continue.
Well, if the court has other questions, I'm happy to answer them. I would just... I've had this argument before with the 5th District, which is essentially that merely because the trial court does not state on the record, I hereby violate your constitutional rights, if that is all it takes to bar any higher court from a review of what happens at a trial court, then in what sense are the rights worth anything?
Well,
if all it takes to violate them is not saying so on the record.
The law is that there's a presumption of fairness, that he's not biased, and the burden is on you to present compelling evidence that there is a bias.
We believe that we have done so, obviously, Your Honor, and I believe when the court reviews those comments made and the extraordinarily attenuated nature of them, of even assuming that these alleged statements from a juvenile facility decades ago are true, of which there is no proof in the record. But even assuming they're true, the fact that the court did not divulge its prior existing knowledge of these comments it itself found pertinent to defense counsel, creates an issue. And certainly creates, in my opinion, the sentencing, at least the appearance of impropriety, which is in and of itself, as the court is aware, enough for this court to take action. If there are no other questions, I will yield the balance of my time and reserve a few for rebuttal.
Good morning.
Good
May
morning.
it please the court. Counsel Andrea Buller for the state of Ohio. I would like to start off, Judge Teodosio, I believe that you had asked with respect to the PSI and how that juvenile record came before the court. And the trial court had the existing PSI. The record indicates that there had been a juvenile court where a prior judge had convicted him of the unauthorized use, I believe, of the motor vehicle. I'm sorry, that he was breaking, entering, and theft, and it was a different judge. Mr. Fortune was sentenced to prison for 3 years. This is the sentencing transcript at 3. And then the trial court says, I picked up a case 3 years later involving an unauthorized use of motor vehicle, to which Mr. Fortune pleaded guilty in 1999. He talks about the sentence that he gave in that case, and then he says, the pre-sentence investigation that was already, I gave the concurrent time of the sentence he was already serving for Judge Brown. That pre-sentence investigation contains information about Mr. Fortune's juvenile record, some of which I think should be mentioned. I think it's pertinent. And then the court goes through that juvenile record and the history and talks about, Mr. Fortune had been, although no charges were actually brought forward, I believe that he had, I'll find the exact, there was a likelihood that he would reoffend, and it was related to a sex offense case.
Well, counsel, let me stop you there.
Yeah.
The court didn't order a PSI in this actual case, the case before us, because it really wasn't necessary, because he didn't have any discretion in sentencing.
Correct.
It's mandatory. So what was the point of going back and looking at old PSIs?
I would say it was mandatory as to the 29072 A1B rape charge, but he also was convicted of sexual battery, where the sentence was up to 8 years. And so Mr. Fortune was convicted also of that sexual battery offense, which I would say the trial court did have discretion, and it did note, I do have discretion. And so I think that he pulled the prior PSI, which is perfectly relevant. It's within the trial court's purview to look, at sentencing, to look at prior judicial records. That would be a judicial record, of course.
So why didn't he order a PSI if he was concerned about what his record was and so forth in regard to the sexual battery?
I can't say for certain.
Did he say on the record a PSI would be relevant?
He did not. There's no
Did he
discussion.
indicate why he didn't order a PSI?
No, it just states that a PSI was not ordered in this court, and then goes into that history. And so from that history, that's where the trial court does note that he just thinks it's pertinent and relevant.
And what was the sentence again on the sexual battery?
The sexual battery was 8 years.
Okay, but that was running concurrent.
Yes, it was concurrent.
So after he said all this prior history, he runs his sentences concurrent.
Yes, because they were, they couldn't merge, they were separate offenses.
No, I understand, but couldn't they have run them consecutive?
He didn't go into the analysis. He decided based solely on that they were separate offenses. He said, I'm going to run them concurrent. There is a threat to the public. He did see that as a concern. And so that's where I think that the consecutive was proper on that basis. When we get into the overall argument where the PSI comes in, it's about bias of the trial court. And this court knows that there's actually a statutory procedure whereby you go through and allege the bias. But in this case, that didn't happen. But notwithstanding that, Mr. Fortune did not object on the grounds of bias at the trial court. The mere fact that a PSI was entered and was reviewed, that's not going to overcome that presumption that a trial court is not, a trial court is presumed to follow the law and not be biased. That's the review of a PSI.
Is this really an issue of bias, though, or is this an issue of knowing facts that are not in the record and considering them? I mean, because this judge actually, I don't know if he knew before trial, but he did have him prior to this time. And that's why I was asking so many questions with the opposing counsel as to, when did we know the judge knew it? Because we knew about his prior risk of reoffending and his prior juvenile offenses or allegations anyway. Would that be proper for the judge to know that when he's sitting as the trier of fact?
Well, every judge has to know, they know their code of professional conduct for them and could recuse if they see that as appropriate. Here, there's nothing in the record that indicates that the trial court felt that it would be biased or had knowledge of existing facts that would be inappropriate. It wasn't until sentencing that it talks about the PSI and goes through the information.
But aren't we really talking about due process of fair trial?
And that's essentially what has been alleged, but when you get to, that bias argument, but at nowhere in this record does the defendant object to the introduction of the PSI. At nowhere in the trial does he object on the grounds that there's bias. When we get to the PSI, there's actually, the trial court does the sentencing, and his defense counsel listens to the sentence handed down by the trial court. There's discussion by the prosecutor, and the prosecutor had brought up, I believe, that with one of his daughters, KF, some kind of marijuana police, stop, and the defense attorney objected at the end of sentencing, saying, Your Honor, I'm going to object. I don't know with respect to that marijuana and the traffic stop or whatever that specific fact was. I'm going to object to that. He could have raised all of the other objections at that point. He didn't see it as, it wasn't something that he wasn't aware of or wasn't in his purview. And so based on that, it's the state's position. There's nothing in the record that indicates the PSI influenced the trial court's verdict in any way. As the court itself has already noted, the trial court found the defendant not guilty of 7 of the 9 offenses. And in doing so, it said, it's not a standard of, I believe, appellant has said, about manifest weight. It's whether you believe, says either you believe it or you did it, and how can you find one victim credible and one victim not credible, and it's inconsistent to say that one is credible and one is not. But the standard's not whether, it's looking at each individual victim, and the trial court saying beyond a reasonable doubt, am I convinced, that this happened to this individual? And as for the victim DM, the trial court said, I believe something happened, but I'm not firmly convinced. I'm fairly convinced, but as for the victim MF, I am firmly convinced. And then he went forward and pronounced sentence accordingly. So I think in this case, looking at the totality of circumstances, we can't say that there was any bias. Not only was it not objected to, and this court's repeatedly said it's not going to review this when there's been no objection. I think it lacks merit in general. With respect to Mr. Fortune's statement, I want to step back at his counsel's statement at the beginning, where he said the aggregate issues in this case rise to cumulative error, essentially. To my recollection, Your Honor, there's no assignment of error about cumulative error in Mr. Fortune's brief. If you believe that each of the assignments of error are without merit on their own, you can't look at this as cumulative error in this case.
Well, I asked that question. He believes he's raised it in the manifest weight argument.
Your Honor, my understanding, the way I heard that question was respect to the credibility and the weighing of the testimony of MF and DM, and how the trial court could find, guilty as to MF, but not guilty as
That's not
to
you, I mean, remember?
I think you said.
Oh, I thought you said. Okay, thank you, I apologize. I heard something different than what you said.
No problem, Your Honor.
Because I wonder why you kept saying that, I'm like, where is she? Thank you.
Yes, Your Honor. Essentially, it's the state's position when you look at this case. We're going to step back to the manifest weight of the argument. Manifest weight argument. The credibility of the witnesses is for the trier, primarily for the trier of fact, and a verdict will not be disturbed on appeal unless reasonable minds could not reach the conclusion of the trial court. Here, Mr. Fortune's argument boils down to that the convictions contrary to manifest weight of the evidence, because DM and MF, his stepdaughters, were not credible witnesses, while KF, his biological daughter, was. Mr. Fortune testified that, or Mr. Fortune asserts KF testified DM and MF formed a conspiracy against their dad to fabricate allegations of sexual abuse. At trial, KF testified about her parents having a volatile relationship. During their marriage, there was a testimony as to a conspiracy that KF said that DM and MF had tried to pull her into to allege those sexual abuse allegations against their father so that their parents would get a divorce. Essentially, the state presented testimony that contradicted that. Both MF and DM denied that testimony, and the state presented rebuttal testimony by way of victim advocate Jessica Musser testified that in a separate sexual abuse case, KF had previously disclosed to her that she had never spoken to her sisters about their sexual abuse cases, and that she hoped that what was being alleged was not true, but she had no reason not to believe that it wasn't true, and that she would be, and KF said that she would be devastated if her father went to jail. In this case, MF testified with no uncertainty that she was touched both orally or with the victim or with the defendant's mouth, as well as with his hand. MF testified when she was 9 years old, she was sleeping in the living room, woke up with her pants around her ankles, and Mr. Fortune was touching around her vagina. She further testified that she ran so upset she ran to her sister's room and she slept in her sister's room that night. She also testified that on 4 or 5 occasions the same series of events occurred, and that she knew at one point that the defendant had used his mouth because she could feel his beard hairs and the wetness of his tongue. She met the elements, and that was never raised with sufficiency. But at trial, then DM testified at trial as well, that she was a rape victim, and that this had occurred to her. Although the trial court didn't find that it was firmly convinced as the DM. DM did testify that Mr. Fortune came into her room to sexually abuse her one night, and she told him no. A short time later that same night, MF came into her room crying because Mr. Fortune had sexually abused her. DM's testimony corroborated MF's account of the sexual abuse. And additionally, there's some arguments throughout the brief about maybe an inadequate investigation, but Mr. Detective Lemon also had interviewed Mr. Fortune, and Mr. Fortune said that he didn't recall any of the sexual abuse in this case, but he taught his daughters not to lie, and if they indicated it happened, it must have happened.
That was because he evidently has some kind of brain injury that he couldn't recall things.
Yes.
Lost his memory.
Yes, that's correct, Your Honor. Taking all of that evidence into consideration and the trial court weighing the credibility of the witnesses, it clearly found the testimony of MF to be credible. And it found GM to be credible, but it just couldn't be firmly convinced, it said. And so that is why it found guilty as to MF, but not as to GM. With respect to the prosecutor misconduct allegations, Mr. Fortune alleges that misconduct on the basis that the state did not investigate the question and questioned KF after she indicated her two sisters had fabricated the allegations against him. The court's aware of the standards for reversal upon prosecutorial misconduct. Here, KF had written 2 journals previously in history. It sounds about made-up stories about, well, she wrote stories about her sisters and her father and gave fictitious names. And essentially, she came forward, and once those documents were found, said that those were in relation to, were true, and was about her life story. Those journals were not disclosed to the state until 12 days prior to trial. And there's no prosecutorial requirement that we have to review and interview every defense witness prior to trial. And the record in this case shows the victim advocate testified, and the prosecutor had elicited that the victim, KF, was the sister who wrote the stories. She was actually a victim in another rape case. She met with the prosecutor and the victim advocate at least 3 times in that case, and they asked in that case if she had ever talked to her sisters about the sexual abuse allegations that they have in their ongoing case, and that's where she made the statement. She had never had that conversation with them. She hopes that it wasn't true, but no reason to doubt that it wasn't true.
Was KF the victim of this defendant or a different one?
A different victim.
A different defendant, okay.
And a completely different.
You need to sum up, you only have 8 seconds left.
Overall, I believe that the appellant has not raised the proper errors. He's waived most of the errors that he's alleged at trial, or alleged on appeal, since he has failed to make those at the trial court level. And I hope that this court reviews the record, defers to the trial court's decision on credibility, and affirms.
Thank you. You have 2 minutes and 44 seconds.
Thank you. I will attempt to clear up my comments that have apparently become their own, taken on life of their own. I merely meant that when this court reviews the issues raised by the appellant for appeal, that there is a common through line about their cumulative effect on the due process that was done here. With regards to the state's comments about the trial court, I think he pulled the PSI here or there. That is not in the record. He does not mention when he pulls them. With regards to what this court...
He wasn't the judge on the case for that PSI from 2002.
He was not the judge on that case. He was the judge on a case immediately subsequent to it, where it does appear that he has reviewed it at that point. So again, this is prior knowledge, in my opinion, based on my reading of the transcript. With regards to the defense counsel didn't object to sentencing, it's mandatory sentencing. Didn't object to comments at sentencing that the judge made after he's already imposed the mandatory sentence. State's counsel has said, well, this witness, she testified to this and this. if merely testifying was automatically enough, then the trial court there would be no need for standards of proof. But the trial court, even in this case, found that at least one of these witnesses testified and testified and testified, and it didn't meet the burden of proof beyond a reasonable doubt. As to the issue about the second argument with regards to prosecutorial misconduct, the argument raised was not necessarily that when the state's correct, there's no law out there that says if you're presented with exculpatory evidence or evidence that at least merits a second look 12 days before trial, that you must take this, and this step. However, that elides the larger issue that we are raising here, which is that the state always has an obligation to pursue justice, not convictions. And we believe that and perhaps Judge Teodosio may recognize this name from his prior life, so to speak, when a Bill Evans polygraph, a respected, internationally recognized law enforcement polygraph, which was passed by the defense witness child in this case, and when evidence of that was presented to the state with, you might want to take a second look at things, instead of taking a second look, the prosecutor personally brought his witness, now whose credibility is compromised by this evidence, into his office and instructed her to make a second statement. That was our issue. Thank you, Your Honors.
And just for the record, the polygraph is not in the record.
It's not in the record. It was not in
So really, we shouldn't even be talking about it. Right?
I disagree, Your Honor.
Okay, all right, thank you. All right, so the court, having heard the arguments, and we appreciate those, we have looked and obviously read the briefs, and we'll take the matter under advisement, go through the record and everything in great detail, and we'll issue an opinion to both sides.
Thank you.